And we're back. This is Josh Jelinski, the financial quarterback. With Katie Von Kohorn, we're talking addiction, litigation of estate, communication with kids. And this is one of my favorite points, Katie. If you have a good child, that kid who, this is me, I want your opinion on this. But let's say you had 3 kids, and one was responsible their whole life, and they did really well financially. And then they get 10% of the estate when you die. That to me rubs me the wrong way. Like if you were a good kid and you get less, have you noticed that? That's been happening more and more, I've heard. Have you heard of that?
I usually try to talk clients out of, disinheriting kids or, leaving different amounts. Some people have, estranged children and they leave those people out. And then their remaining kids, they leave, in equal shares. And that's fine. The 10% is a tough, it feels like a slap in the face to the child who's done everything right and gets 10%. Although there are rare situations where a child who's a caregiver gets a larger share and that is communicated to everyone ahead of time. And that's, it ends up being fine. But I wouldn't, don't ding your kids because they did well.
As the kid who was responsible, I was highly offended when my mother disinherited. No, it didn't happen. But I've heard of cases like that. And, to me, it's like, don't penalize them when you die for doing well. Now, if they then want to disinherit themselves and give to a kid who's maybe not done as well, that's fine.
Yes, then they can absolutely do that. You can do something which is called a disclaimer. If you say, I've done really well, I don't need this money, thanks, Mom, but, I'd like to help out my siblings who aren't doing as well, you can disclaim that inheritance and have it passed to the other beneficiaries.
And not only do I not think it's fair, I also think, well, what if that kid who's really successful in your mind gets disabled? What if they develop a health problem? What if they lose their job? Sometimes, success is not guaranteed. So that's interesting.
Absolutely.
So I like you're a very communicative attorney. There are a lot of good attorneys, but I've never, you're a little more, it's actually refreshing, kind of like really what people are going through. So you like communicating. What are tips for communicating? So I'm going to give so if you have 3 kids, you sit them all down. What do you do? How do you have that family meeting not turn into a fight?
Sure. So sometimes it's easier to have the family meeting with one child at a time. If everybody gets along and, you've had kind of these meetings more since your kids have been young, that's one thing. But, starting the conversation when they're already adults is harder. So sometimes, sitting down one kid at a time and saying, this is my estate plan. If there's one person who's closer geographically and is going to be like the person to come to the house and find the will, et cetera, that person should know where everything is. If you have another child who's farther away, you can tell them when they visit or, have a video call with them and say, this is my estate plan and I've named your sibling, as the executor, not because you're doing anything wrong, but because you're so far away and it will be easier for them to access all of the paperwork. So when you frame it kind of like that, that you're thinking of each child individually, you're trying to plan to be considerate of them as well as of their siblings. Sometimes that's a good strategy.
Yeah, I also don't know. I mean, being an executor is not that fun of a job. It's like, it's
not at all.
It could be really annoying. And so how do you avoid estate litigation? families that are contentious, stuff like that. What are some tips for that?
So we have, in many states, you could have what's called a no contest clause. So you put that in your will and you say, don't sue over my will or you're out. And people will do that if they, see some conflict that's coming down the line, or if one of their kids, just doesn't get along with anybody, they're estranged, and they know that a contest is kind of imminent. So that's one thing you can do. Another common thing is for people to sue over undue influence, which means, you were living with mom, you forced her to sign her will naming you as the beneficiary, and I got nothing, so I'm going to sue. In that case, to plan to avoid that, some people will have, a doctor's certificate saying that they're competent. I don't do this often, but some people want to, videotape the signing. Of course, during COVID, we had video signings, so you can kind of add that on to your existing estate plan and have a questionnaire where you kind of go through with the client, what's your name, who are your kids, what's today's date, who's the president, those kind of questions to kind of establish that they were competent when they signed their documents.
So do people win those challenges? Like, somebody, let's say I leave all my money to, I don't know. Let's say I leave all my money to my wife and then I die, leave my money to my wife, and she marries Fabio, and Fabio persuades her to name him as the beneficiary upon her demise because they are in love. How does someone protect themselves?
So it depends on what your documents say.
Yeah, it depends on what the documents.
If you wrote them so that your wife has a power of appointment, and then she can change what happens to everything after you die. But if, you say, my wife is going to be the beneficiary, but then after she dies, it goes to my kids, she can't change the way everything passes if you put it in a trust. Yeah. So, for people who are more concerned about control and that someone, either spouse or kids or grandkids, could squander the inheritance, a trust that will last for a few generations is the best way to kind of guard against that.
So make sure you don't give power to change appointment. But that's the thing, though. When I talk to most people, I would say 90% of the people who are astute, so that's like 1% of all listeners, let's say, when it comes to these matters. No offense to my listeners, there's some of the most astute people out there, but the most astute people that I'll see on a regular basis, I mean, some will have irrevocable trust, but a lot will have like a will, a living will, a revocable trust. They'll have their, A, B things, they'll have all this stuff, but everything can be changed. Everything can be revoked. So that's a big danger with that type of stuff, right?
Sure. So, you can only control your own estate plan. So if you leave anything outright, not in a trust, then that person, owns those assets. And so they can turn around and do whatever they want with them. So sometimes it's hard for people to kind of, go through the steps. So you would go through a few different scenarios and say, this is what happens if, your spouse gets remarried, for example, or this is what happens if, your kids go through bankruptcy. So kind of illustrating different scenarios for clients will help them to see, okay, so I do want the trust to continue for my kids' lifetimes, or I do want my spouse to have a power of appointment, but only for my kids, for example.
No, fantastic. And then people will say, hey, I don't want control in the grave, but if you don't have control in the grave, somebody else might have control when you're in the grave too. So, folks, give us a call, 888-988-JOSH. If you want help establishing a battle plan for your finances from an estate planning perspective, give us a call, 888-988-JOSH, 888-988-5674 during the break. I'd love to meet with you, shake your hand, We're giving a free 45-minute strategy session to those of you who schedule and keep your no obligation strategy session. Give us a call, 888-988-JOSH, 888-988-JOSH, 888-988-5674. And we're back. This is Josh Jelinski, the financial quarterback. We are with Katie Von Kohorn. Say that 5 times. Katie Von Kohorn. Yeah, I'm sure people... What if people botched your name? What is the funniest thing that people have said your name? People would say like Josh Jajinski.
Oh, people just give up. Sometimes they add or subtract letters,
Yeah, like Katie Convohorn or Katie Van or something like that. I could see. Yeah, that's funny.
Yeah, Van is very common.
And then you have like, people will say like Josh Jasinski. Or it's funny. Yeah. Sometimes I think people get intimidated by just more letters at the end of a name, or something. So we're talking about estate planning, communicating with kids, avoiding estate fights. And so if one has a revocable living trust, that's what, Susie says, everybody should have a revocable living trust. They're not really doing anything to protect their money when they're in the grave, right? It's really just a probate avoidance tool and a distribution tool. Can you explain that a little bit? Because people think it's like the be-all, end-all.
The revocable trust is kind of the first, it's the first tax planning tool that I recommend to clients, particularly if they're looking to avoid the Massachusetts estate tax or defer it as much as they can. But if you put a revocable trust in place, your trust is a pass-through during your lifetime. It doesn't provide you with creditor protection. And it acts as you. It is only, you can put assets into it. And I often recommend that people do that so that they can help to keep assets out of probate. But it becomes irrevocable when you die. And so that's when the provisions of the trust kind of become more important. And at that point, it's more of a preference thing, like we discussed earlier, with how long you want the trustees to be able to hold the trust property.
No, wonderful. So as it relates to estate planning, what about addiction? A lot of people have kids now struggling with addictions or mental illness. What do you do in cases where I have 2 kids and one of them is struggling with addiction, one doesn't? What do you do in those cases?
Yeah, so it's helpful to have an independent trustee and not have the kids serving as trustees of each other's trusts, for example. And sometimes people will say, my kid has some issues and they might need to qualify for benefits. And then in that case, you can put special needs language into the trust and have a discretionary trust for the kids, which is more protective for creditor issues usually. And in Massachusetts, it's more protective. So that you can avoid, if everything passes outright to your child and your child loses that money to their addiction, then they're stuck. So in those cases, a lifetime discretionary trust with an independent trustee is usually the best option that you can use.
And who do you pick for independent trustees? You said a bank or trust company. How do you make sure it doesn't cost an arm and a leg?
So, you can, if you ask, your local bank or trust company, they'll have a fee schedule, and it tends to be, kind of 1% on the first X amount, and then it goes down from there. If you have, a good family friend who happens to be like a financial advisor or something and is good with money, you can see if they would be able to serve. Some advisors can't serve because of their restrictions as investment professionals, but you can always ask. Some people will name their CPAs. In Massachusetts, some people name their attorneys. Sometimes I will serve as a trustee. But again, it's family and client driven. So, I can recommend different people or institutions to clients depending on what their preferences are.
No, fantastic. And what about a lot of people will leave like special needs trusts trying to get money to their kids so their kids don't lose disability benefits or things like that. What tips do you have for those people?
Sure. So you want to find an estate planning attorney who does a lot of special needs planning. And, if a complicated special needs situation comes into my office, I often refer to one of my partners who specializes in those kinds of trusts to make sure that you're getting that specialized plan. If you go to a general estate planner, they might put in their provision that they've been using for years and years, and it might not be as protective as you think it is. So make sure you have, someone who specializes in those special needs trusts that you will need for your children or other beneficiaries.
And how would you, I guess it'd be a special needs trust or some type of irrevocable trust, so they only make X income, because if they make more than X income, they lose their benefit type of thing?
Yeah, and it depends on the type of benefit, again. So it's very individualized at that point.
Okay, wonderful. So you talked about communicating with kids, protecting money from creditors. What other tips on communicating with kids? I'm starting now. I'm telling my kids they're going to get nothing. No. Or they'll all have to work together. Like you said, start small. My kids.
Yeah, exactly.
I've wondered too.
And I wanted.
Oh, go ahead.
And not to neglect your lifetime plans too. So your power of attorney and healthcare proxy. If one of your kids is going to be named as the healthcare agent, make sure, the others know that. And if you're naming them in a certain order, that's important, because if you're in a coma and they're fighting over who gets to make that decision, that's not where you want the conversation to take place for the first time.
Yeah. What if you don't make that decision and two of the kids want to pull the plug and two of them don't?
I think it would be up to the physician, at least in Massachusetts. That's my understanding, but it is very state specific.
Yeah. Well, I don't want my physician pulling the plug. I think as healthcare costs go up, I don't know. I want hope for me. But, it is something good to, you don't want your kids making that decision. It could be a totally different decision. And you don't want them to have the pressure of making that decision. It is a pressure that
Right.
sometimes you really don't want your kids to make. And I mean, it can be a real tragedy. So folks, we're going to take our final break of the hour with Katie Von Kohorn. Katie, do you have a website our folks can learn more about your work?
Sure. It's at our law firm is Kasner and Edwards. So it's C like cat, A, S like Sam, N like Nancy, E, R, and then the word Edwards. So if you search that, you'll find me on that website under the letter V like Victor.
Great. So Katie Von Kohorn will be back. Final segment. Give us a call, folks. 888-988-JOSH, 888-988-5674, and schedule your free 45-minute strategy session. And you'll receive a book, The Income for Life Blueprint, when you call us now, 888-988-JOSH, for your free, no obligation, second opinion on your wealth. We'll be back after this. And we're back with Katie Von Kohorn of Kasner Edwards talking about estate planning. What estate planning tips? It's been a great hour talking about all types of estate planning things. What haven't we talked about? I would say life insurance trusts, maybe spousal lifetime access trusts are hot. Anything that you want to talk about that we haven't talked about before I ask my two questions?
Sure. Well, I wanted to briefly mention digital assets, which you don't have to have cryptocurrency to have digital assets. Most people now get their financial statements online if you're paperless. And so it's important to plan for those assets as well so that your beneficiary or your successor trustee doesn't lose access to any of those after you pass. It's kind of it's a newer type of plan that, most states have a law called the Uniform Fiduciary Access to Digital Assets Act. And it's usually the revised version. Massachusetts doesn't have that law yet. I think we tend to be one of the stragglers in that regard. But so usually your executor can access some of your digital assets, but it may not be what you think. Some of the file sharing sites, personal photos, frequent flyer miles, they all have their own rules. So it's important to kind of think about that universe of your assets as well.
Yeah,
and then if you have cryptocurrency,
that's a lot. Yeah.
They can be passed on most of the time.
Yeah, I got a bunch of points racked up on my Amex card. I got it. What happens to them? That's a great point. I've totally forgot about that. What about irrevocable life insurance trust and spousal lifetime access trust? I've been hearing, back in the day, everybody said put your life insurance in a trust. Then I've been hearing spousal lifetime access trust where like you own, and I could be botching this, I'm an attorney. Like, so if let's say I have a spousal access trust with my wife, she can then access the cash value in my policies, but it's still out of my estate. Do you want to talk about that? That's a little confusing to me.
Sure. So insurance trusts are a great planning tool, especially for, younger couples who can get, cost-effective life insurance. Usually you can get a few million of coverage for not that much money. And if you put that in an irrevocable trust, then if you pass, your spouse and your kids will be provided for, and it's out of your estate for estate tax purposes. Very high net worth individuals will also use insurance trusts to plan for the federal estate tax because the asset, the death benefit that comes into that insurance trust can pay the federal estate tax so that you don't have to sell your other assets to do that. And then spousal lifetime access trusts are hot right now because of the impending predicted decrease in the federal estate tax exemption amount. So what that means is if you have, you and your spouse have $25 million, you haven't used any of your exemption yet, one spouse can put his or her exemption. So you can put that $11 million in a irrevocable trust for the benefit of your spouse. And then you've used up your exemption. If the exemption level goes down, you don't get dinged on that. And it's important, the spousal part is important for people who want to keep that door open to use those assets if their situation changes. So, if in the future, the market crashes and your other assets kind of go down in value such that you have to pull from that spousal trust, both spouses can still kind of get the benefit of it, even though one spouse is the beneficiary. The risk with those types of trusts is that you'll get divorced. And if you get divorced, your spouse still has access to that a lifetime access trust, but you do not. So, and then if the spouse also predeceases kind of, earlier than you had feared, at that point, the donor, the person who gave away that 11 million can't have access.
But wouldn't it be mutually assured
right
destruction? Wait, what did you just say there? I cut you off.
Oh, so it's, it's kind of big right now because we think the federal exemption amount is going to go down.
So what about, but wouldn't it be mutually assured destruction? So like if you're married and I have one for me, my wife has one for her, and we're each other's trustees, so to speak, you kind of both have access to the others.
Yeah, you do need, so you do need an independent trustee. If you have those kind of mirror trusts, you will get in trouble with the IRS. Those are called reciprocal trusts. And the IRS will come after you and say, this is not a real gift. These trusts are the same, and each of you is the trustee of the other's trust. So you have to be very careful when you're doing these spousal lifetime access trusts to make sure that the trusts are not the same if both spouses are going to do one.
Interesting. Well, I guess you could have a relative or something who's more neutral or something, or a friend, I guess, or an independent trustee, right? I mean, I guess that would be the way around that thorny issue. Well, this was a lot of fun, Katie. Katie Von Kohorn, thank you for joining us. And any final tips that we haven't talked about in conclusion?
I would say, know where your paperwork is. It's paperwork now or paperwork later. So the more organized that you can be, the easier it will be for your heirs after you've passed.
Yeah, know where your paperwork is. That's a good way to end. Yeah, we give a binder to all of our clients so they can have all their stuff organized. And it sounds archaic, like here's a binder. In the world of digital assets, I want an online vault. Well, that's great too, but it's also good to have old, fashioned paper in a binder. And if you want that, folks, you can get that when you schedule and keep your no obligation review at 888-988-JOSH, 888-988-JOSH, 888-988-5674. So glad to have you on, Katie. Hope to have you on again in the future.
My pleasure. Thanks for having me.
Thank you. So, folks, we'll be back after these messages with your questions. 888-988-JOSH, 888-988-JOSH.
The preceding program was sponsored by the Jelensky Advisory Group.
Any awards, rankings, or recognition by unaffiliated third parties or publications, including 5-Star Wealth Manager, Advisory of the Year finalist by Senior Market Advisor, and top of the $1 Million Roundtable, are in no way indicative of the advisor's future performance or any individual client's investment success. No award, ranking, or recognition should be construed as a current or past endorsement of Josh Jelensky or Wealth Quarterback LLC. Information regarding specific awards, rankings, or recognitions is available on the Wealth Quarterback website at www.jelensky.org. All investment strategies have the potential for profit or loss. Investment strategies such as asset allocation, diversification, or rebalancing do not assure or guarantee better performance and cannot eliminate the risk of investment losses. There are no guarantees that a portfolio employing these or any other strategy will outperform a portfolio that does not engage in such strategies. This broadcast should not be construed by any client or prospective client as a solicitation to effect or attempt to effect transactions in securities or the rendering of personalized investment advice. Due to various factors, including changing market conditions, the information discussed in this broadcast may no longer be reflective of current positions or recommendations. While information presented is believed to be factual and up to date, Josh Jelensky and Wealth Quarterback do not guarantee its accuracy, and it should not be regarded as a complete analysis of the subjects discussed. The tax and estate planning information discussed is general in nature, is provided for informational purposes only, and should not be construed as legal or tax advice. Listeners should consult an attorney or tax professional regarding their specific legal or tax situation. Advisory services offered through Wealth Quarterback LLC.